Professor Subbarao Saab, we should start?
We can start. We can start.
Sure, sir.
Okay. A very good morning to everyone and welcome to today's session. I'm your host for the session, Anushmi Jain, Faculty of Law, the ICFAI University, Dehradun. I welcome you all to the celebration of National Law Day, 71st Samvidhan Divas, which is organized by ICFAI Law School, the ICFAI University, Dehradun. I would like to take the privilege to extend a heartwarming welcome to our first speaker of the day, Professor Dr. T.V. Subba Rao, Professor NLSIU Bangalore. Thank you, sir, for accepting our invitation and being with us today. Also, I would like to extend a warm welcome to Professor Dr. Muddu Vinay, Vice Chancellor, the ICFAI University, Dehradun, in absentia, Brigadier Rajiv Sethi, Registrar, the ICFAI University, Dehradun, in absentia, Professor Dr. Yugal Kishore, Dean, ICFAI Law School, Dehradun, Mrs. Monica Kharola, Academic Coordinator, ICFAI Law School, Dehradun. I would also like to welcome all the participants who have joined us today. Now, I would like to pass on the mic to Professor Dr. Yugal Kishore, Dean, ICFAI Law School, Dehradun, to address the gathering. Over to you, sir.
Thank you, Ms. Anushmi Jain. Am I audible?
Yes, sir.
Okay, thank you. Respected key speakers of this historical day, Honorable Mr. Justice Pinaki Chandra Ghosh, Chairperson, Lokpal, former Supreme Court Judge, Supreme Court of India, Honorable Mr. Justice V. Gopal Gowda, former Judge, Supreme Court of India, Honorable Professor Dr. T. Subba Rao, sir, Professor, National Law School of India University, Bangalore, academicians and law professionals, Pan India, academic coordinator of ICFAI Law School, Madam Monica Kharola, system administrator, Mr. Akhilesh Singh, organizers of this program, Ms. Anushmi Jain and Mr. Vishal Bera, my esteemed staff here and students. Today is a historical day. The Samvidhan Divas, the Constitution Day. Earlier, we used to celebrate it as Law Day. On this day, November 26, 1949, the Constitution of India was adopted, enacted, and it was promulgated on January 26, 1950. We have on this day three jurists among us. The first one is present here, Professor Dr. Subba Rao Saab, and two other I have already named. So on my behalf, Professor Yugal Kishore, Dean ICFAI Law School, ICFAI University Dehradun, on my behalf, as well as on behalf of the university, wholeheartedly thank Sir that today is a very auspicious day. Sir has got a very busy schedule. But even then, all the three have been so kind to enlighten us, to support us, to motivate us, and inspire us on this historical day, which we call it as Constitution Day. I further wholeheartedly welcome all of you, and especially our three jurist speakers of the day. My dear student friends, this is for you that today is a very historical day. As you know, this day the Constitution was promulgated, as I told you a few minutes back. Constitution was adopted. Actually, there was a great freedom fight by the persons in India to make India independent, free, and a dream India, a India in which we have our own aspirations, our own motto, our own vision, our own mission, our own values. So once we got we were in the process of getting independence, then these all aspirations which I just discussed a few minutes back, they were all codified into the constitution, and thereby this constitution has come to on 1949 on this day, November 26. Now, at that time, neither I was born nor you were born. So we do not know exactly what are the aspirations, what was the dream of our freedom fighter. And we have come across quite a long time, 70 years have passed. But even then, the basic goal, the basic motto, the basic vision and mission of the constitution has not been fulfilled. So on this day, I wish all of you that we should work hand in hand in cooperation and see that the vision and mission of the constitution, the Kalpana of Ram Rajya, which was there in the minds of all our freedom fighters, is fulfilled. With that motto, the Constitutional Day is celebrated throughout India in every law school and every big institution in the country. And we have to take a pledge that in future, my dear student friends, it is for you that we all will abide and respect the Constitution. We'll see that all the goals which are given therein are fulfilled. We have to look into that what we can do for the country, what we can do for the fulfillment of the goals of the Constitution, and not that always asking what the country can give to us. So here, when the Constitution was promulgated, at that time, the emphasis was there on rights. We had a right-oriented jurisprudence in India. But now, at that time, it was very essential because we were not aware of our rights. We were all in a very pathetic condition. But now, India has developed to some extent. Now, the time is there that we develop duty-oriented constitution and we follow the duties and see that all the aspirations which are there in the constitution, which are clearly demarcated in preamble and further enumerated in the constitution, they are fulfilled by our efforts. With this, I thank all of you for coming to this particular platform on this Constitutional Law Day. And further, as I have already told, that we have a great constitutional law expert with us and a jurist. And so now I request our Anushmi Jain to go ahead further, and we are all eager to listen to our learned professor. So I don't want to be there in between you and him. So Anushmi Jain, please go ahead with.
Yes, sir. Thank you so much, sir, for your kind words and valuable insight. As today is 71st Samvidhan Divas, keeping our faith into the Constitution, I would request Mr. Vishal Bera, Faculty of Law, to kindly recite the preamble. Over to you, sir.
Thank you, ma'am. Ma'am, is my screen visible?
Yes.
Yes.
Okay. To bestow our faith upon the Constitution of India and with the due permission of the Speaker, and our Dean Sir and our Academic Coordinator, ma'am, I would request to read out the preamble to the Constitution of India. So, we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, ma'am. Thank you so much, sir.
Thank you, sir. Now, I would take the privilege to introduce our speaker, Professor Dr. T.V. Subbarao. Professor Dr. T.V.
Be brief,
Subbarao.
huh?
Sorry, sir.
Be brief. Very brief.
Sure,
Because
sir.
time is up. Already 10 minutes over.
Yes, sir. Sure, sir. Professor Dr. T.V. Subbarao, presently working as Professor Emeritus, BIPS Delhi, and visiting professor at NLSIU Bangalore, started his career as a teacher of law in 1978, professor of law since 1992. Professor Rao made marked contributions in rationalizing and strengthening the administrative reforms and systems in the universities in which he worked. He has been instrumental in facilitating the university's access to funds under the various schemes of the UGC and from other agencies. He held many academic, administrative, and supervisory in the university system. Amongst the many, few are acted as an administrative and supervisory in the university system, visiting professor, director, research and development council, chairperson, postgraduate council, NLSIU Bangalore, formerly chairperson, undergraduate council, NLSIU, acted as coordinator for the test conducted for recruitment on the behalf of Competition Commission of India 2011, 12, 13 under the aegis of NLSIU Bangalore, formerly coordinator for ENVIS, Center for Environmental Law and Policy, NLSIU, OSD for CLAT Consortium of Universities 2019. Professor Subbarao has been 5 times nominated as the convener of LawSet by the government of Andhra Pradesh. So the more we say about you, the less it is. So with this, I would now request Professor Dr. T.V. Subbarao, sir, to kindly take over the session. Over to you, sir.
Namaste. Good morning, everybody. Am I audible and visible?
Yes, sir.
Yes, sir.
Yes, sir. Absolutely.
At the outset,
Yes, sir.
let me thank the charioteers of this program who have given me this opportunity to talk to you on the auspicious day of adopting the Constitution. This is celebrated as a Constitution Day with specific reference to the Dean G. Professor Yugal Kishore Ji and the person who has invited me and often reminded me of that because he thought that because of my old age I will be forgetting, Anushmi Jain, and wonderfully he has discharged his duty of reciting the preamble, Vishal Vera, and then the authorities of the university. To all of them, I sincerely thank for giving me this opportunity. Friends, Greece, Egypt, and Rome have all disappeared from the surface of the earth. But the name and fame of India, our country, has survived the ravages of time and cataclysms of ages. Surely and surely, I tell you, my friends, there is an eternal element in us which had frustrated all attempts at obliterating our nation. These are not my words, translation is mine, but these are the words of poet Iqbal. Friends, our Dean Saab has given the parameters of our talk, but one rider I would tell, generally I will be exceeding my time, that is my habit. Once I enter into classroom, it is 1.5 hours, that is mentally, it is rather tuned to that. But today I may have to close it within rather before 11 o'clock, because at the stroke of 11 o'clock, you will listen to the president who is going to recite the preamble for the whole nation. So, be it as it may. What we will have to understand is that all the constitutions are the heirs of the past as well as the testators of the future. Our constitution fulfilled it. Yugal Kishorji was telling we were not born at that time. Even I was born only after it was adopted. But the thing is that if you go into the history, it will be very fascinating experience. What were the aspirations of those people who adopted the constitution? They sacrificed their lives. They sacrificed everything for the sake of the country. They sacrificed their familial comforts. But what we are doing now, having every comfort, we are sacrificing for our economic interest and another interest, the entire interest of the nation. So let us see how far we are able to rather live up to the mark. Look at 70 years ago, more than that, when the entire world was looking with keen interest at newly born nascent democratic republic. In the preamble, my dear friend Vishal Bera, I tell you, it is not democratic comma republic. It is democratic republic. It is like adjective it was used. Okay. Then the entire world was looking with keen interest at newly born baby nascent country to see how it is going to formulate its constitution. We started our tryst with the constitutional governance, tryst with the destiny speech of Pandit Jawaharlal Nehru on the midnight of August 14. That is one thing. This is our constitutional governance to realize our dreams and aspirations. On 26th November 1949, this constitution was enacted and adopted, and it came into force on 26th January 1950, except for few articles which came into force on 26th November 1949 itself. It was enacted and adopted, but members signed on the script of the Constitution on 24th January. Leaving these dates apart, now they are mostly irrelevant for us. We have our Constitution now. Earlier, this day, that is 26th, what is that? November 1949, that to mark that aspect, every 26th November 1949 was celebrated as a national law day. Prior to that, many people did not celebrate this day. But in the year 2015, to mark the occasion of 125th birth anniversary of Dr. Ambedkar, the government has decided to celebrate it as a constitutional day in a fitting tribute to that great man who has burnt midnight oil to formulate this constitution with the help of fellow drafting committee members, and also Sir B.N. Rao, who was constitutional advisor to the Constituent Assembly. So, having awareness of constitutional law, I am specifically using the word constitutional law, not merely the constitution. constitution what we have adopted and the content thereof is bigger than the original enactment. Rather, we cannot call it as enactment. Original constitution, acts are made under the constitution. Okay, awareness of constitutional law is irreducible minimum for every Indian. If education makes you a person as a human being, the knowledge of the constitution makes him a responsible person. It is not meant only for few people. It is not liar's paradise. It is not merely for the judges. It is not merely for law students. Everybody has a stake in the constitutional law. From Prime Minister down to the attender just standing in front of your room, everybody has a stake in realization of the goals and aspirations that are mentioned in the Constitution. Whether you are a student of history, political science, economics, policy studies, human rights, gender mainstreaming, international relations, this is irreducible minimum. The architect of the Indian Constitution, Dr. Ambedkar, expressed sincere hope. We do not know whether we have lived up to his aspirations. He said, I feel that the Constitution is workable. It is flexible and strong enough to hold the country together, both in peace times or during wartime. He added further one rider. Indeed, if I may say so, if things go wrong under the new constitution, the reason will not be that we had a bad constitution, but the reason would be to say that the men working are wild. The experience shows us that the men working on the constitution are not bad, but they were not at their best. As a person, as a student of constitutional law still, I may see whether it is executive, legislature or judiciary, we require to put more. Improvement is required in every angle. Okay. And then if I am harsh, I may be excused. Sometime back, that may be valid even today. India certainly requires a caution, a cautioning call against legislative lethargy, executive inertia, and judicial overreach. No period is more appropriate for study except this corona period. In spite of these limitations, my friends, Indian Constitution stood the test of the times. In its more than 70 years of existence, it has faced not one challenge, many challenges and onslaughts. There were attempts of subversion. The newly born countries along with India, and after that, many countries lost their scope. And then they changed their constitution, but it stood the test of the times. There were attempts of subversion. It was tampered nearly 104 times at the rate of 1.5 amendments per year since 1950. Sometimes for political expediency. Sometimes really we wanted to improve the constitution. The organs created by it, including judiciary, suffered wounds. Certain wounds are self-inflicted as well. Self-inflicted wounds, even on Indian judiciary, executive, or the legislature. It has witnessed and it was instrumental to many phases of development of India. It has facilitated mixed economy in the beginning. It has facilitated socialist leanings during 70s, and now it is also facilitating globalization. Did it come in the way of economic reforms at any given point of time? The answer is no. From industrial to technological society, Indian constitution has facilitated and never stood in the way of rather implementing the reforms. The saga of the development of the Indian constitution is a mixed basket, but not always a happy one. It has like what you call ECG graph. If ECG graph is going up and down, you are alive. If it is straight line, you are dead. So like that, Indian constitution, in the beginning itself, I told you, is a live document. Okay, it is a live wire. If it is dead, my friends, the growth is stunted and we are undone, and the nation itself will be a dead nation. So that is the importance of the constitution. Constitution is a fundamental law of the country. Why I am saying that? All the statutes are made under the constitution. All the rules, regulations, notifications, bylaws, orders are all subject to the provisions of the constitution. So constitution is a fundamental law of the country under which everybody has to act. It is a time to remember the antecedents of the constitution if you verify. And remember the contribution made by founding fathers. Feminists say that it is founding mothers. I also prefer that expression, founding mothers. For information, for nearly 20 years I was a professor in an exclusive women's university. As I have told you, it would be fascinating experience to travel through the evolution of the Indian constitution. But for the sake of brevity, I am not going into the lengthy exposition of legislative and constitutional history, because you can study it in 3 periods. 1600, when Britishers entered into our soil with the Farman of Jahangir, we welcomed them thinking that they are trading people, and ultimately by 1858 those pretensions have gone. That is the first period. The second period is transfer of power from East India Company to the crown. Once that has happened, my friends, all the laws were passed to facilitate their stay in India. Even now we are governed by, not by the laws made by independent India, but by the laws made by British Parliament during that period. You take Indian Contract Act, you take Indian Penal Code, you take Indian Evidence Act, Transfer of Property Act, dozens of acts were passed during this period, 1858 to 1847. Even your Epidemic Act of 1897, which you are using now, was passed when the Britishers were there. We did not have that legislative preparedness. Okay, and then the third period comes, that is making of the Indian Constitution from 1946 to 1949, and then India has proclaimed as came into force Indian Constitution on 26th January 1950, my friends. In 1919, first responsible government we tasted. there was a double government. Some Indians were inducted into the cabinet, but nevertheless, unimportant portfolios were given, and Governor General has power even to veto it. Okay. And then, in view of those defects, they brought in Simon Commission, and a result of which Government of India Act of 1935 was passed. It is considered to be a mini constitution. Even in the framing of the Indian Constitution, you can see many provisions of Government of India Act were lifted and placed under the Indian Constitution. But however, at that time, our leadership did not accept this one. It has worked in the atmosphere of boycott. It did not percolate into the entire India. Only it was working at provincial level till 1937, and then over which, in the mean period, Second World War broke out. British government declared India as a belligerent state, even without consulting anybody in India. That has caused heartburn. All the Congress ministers resigned. The scheme of Government of India Act of 1935 came to a stall. When they were telling about Indians are not competent even to make constitution. Long back we had Univocent Bill of Rights, Nehru Committee Report of 1928, Motilal Nehru's. Nearly 16 provisions relating to fundamental rights and directive principles were there reflected in the constitution. It is not as if Indians were lagging behind. It is because there was no will to transfer the power. That is why in 1942, they could see the movement, Quit India movement, and failure of Cripps machine. As a result of which, in 1946, there was cabinet mission. Lord Pethick Lawrence, Stafford Cripps, and Mr. Alexander, they were there in the committee. They have recommended for the constitution of Constituent Assembly to frame the constitution. An interim government. At the time when the Constituent Assembly was brought into existence, initially it worked in an atmosphere of boycott from Muslim League till the partition was over. It was not a sovereign body. It was under the plan that it was brought into existence. After Indian Independence Act of 1947, it has become a sovereign body. Okay. Now, everybody must have remembered that great speech of Pandit Jawaharlal Nehru on August 14th night, and then next day after the stroke of midnight on 14th August 1947, not only Pandit Jawaharlal Nehru's speech that we should note, every member of the Constituent Assembly, like today, we are serving the preamble. Every member of the Constituent Assembly, including the President, stood and took pledge as members of the Constituent Assembly to dedicate themselves in humility to the services of India and the people of India. That was the commitment which they have made. Pandit Jawaharlal Nehru, not only that speech, another speech is there. There is another person, he remembered Mahatma Gandhi, who is absent here and who must be in the minds of many of us today. What many? Everyone at that time, the great leader of the people, the father of the nation. And then framing of the constitution, if you can see, The debates commenced technically 9th of December 1946. But serious work started only the later part of 47. The Constitution of India was officially enacted and adopted on 26th November 1949, and it was signed by the members of the Assembly on 24th January. It was adopted, so it is deemed that it has come into rather existence on 26th November 1949. Who was the first president of the Constituent Assembly? Till Rajendra Prasad was elected as the permanent chairman of the Constituent Assembly, Dr. Sachidananda Sinha who was the oldest member and veteran, even in Imperial Legislative Council. He was rather there, and he was Kripalani has brought him and proposed, and he was made as temporary chairperson. Our Dean was asking, what was the aspiration? You look into Dr. Sachidananda Sinha's observation. Many people, we do not quote him. We forget him almost. That reasonable agreements, judicious compromises. Reasonable agreements, judicious compromises are nowhere more called for than in framing the Constitution of India. He added that Constitution that you are going to plan may similarly be regarded for immortality. It should be there forever. If the work of a man may justly aspire to such a title, and it may be structure of adamantine strength which will outlast and overcome all present and future destructive forces, it should withstand. That was the aspiration of the first technical chairman of the Constituent Assembly. It worked for 2 years, 11 months and 18 days. As I have told you, Sir B.N. Rao, who was constitutional advisor to the Constituent Assembly, was specifically sent abroad to see the working of other constitutions and get best out of it. How much they strived to get best out of everything. That is what I require when I said that they may not be bad people working on the Constitution, but best has to come. That is what we want. So you want to hear the respect given to that person. He went to Justice Frankfurter to ask him whether we can include due process clause in the Constitution. He said no. He was waiting outside in the hall when Justice Frankfurter is engaged. He has sent a slip. He came out. They had discussions. After the discussions were over, Justice Frankfurter said that here is a man who knows more than anybody else, even about our Constitution, even about American Constitution. So those were the intelligent people. Dr. Ambedkar, Allada Krishnaswamy Iyer, Munshi, several others contributed their might. During January 1948, the draft constitution was published for public debate. It is not as if we the people are not there. It is not as if all the persons in the Constituent Assembly were not the representatives of the people. But whatever it may be, it was referred to the people, and people have submitted their suggestions. Some of the suggestions found their place in the Constitution itself. So can you say that it is not true representative in character? And then, as I have told you, after the Constitution was adopted, there was a small comment. Not many people, but few people rather, it may be a fact also if I tell you the thing. They said it appears that the Constitution of India is a patchwork constitution. And it is un-Indian. We wanted to hear Veena, but we are hearing Western music. That was the comment made. But if you refer to the provisions of the Constitution, you will find that it is a homogeneous patchwork. You may see similarities between Indian Constitution and other constitutions, but we are not bound to follow the same experience. Okay. For example, parliamentary system, not totally copied from England, with its qualifications and conditions, it is taken from England parliamentary system. To that extent, this is correct. Federal free church, we have taken from the Government of India Act of 1935 itself, which in turn based upon British North American Act of Canada. So the origin is Canada. The fundamental rights, they say, we have taken from American Constitution, not totally true. There at that time, Universal Declaration of Human Rights also was there. So we have taken even from those things. Example is Article 14. Directly you will find equality before law and equal protection of the laws within Article 7 of the Universal Declaration of Human Rights. So it is not true to say there are limitations which were not there under American Constitution, but we have placed under the Indian Constitution. So, and directive principles of the state policy from Irish Free Constitution, trade and commerce from the experience of Australia, not merely a copy work. Diluted form of due process in the beginning, as interpreted in A.K. Gopalan versus State of Madras, AR 1950 Supreme Court page number 27, that is one aspect. Subsequently modified by Maneka Gandhi versus Union of India, AR 1978 Supreme Court page number 597. Okay, these were emergency provisions were taken from German Reach. Okay, these are the facts about the framing of the Constitution. The dichotomy between enforceable fundamental rights and unenforceable directive principles was adopted, even though they were in the same basket initially, because the government requires time to implement various directives. But now you can see after 1978, how many directive principles were read into fundamental rights. We had single citizenship, single hierarchy of courts, from Mafizil Court up to the Supreme Court. Secular principles was rather a different aspect of secularism, which they Western countries understood. All the religions are given the same rather freedom. Every citizen has freedom of conscience and freedom to profess, propagate, or practice religion of his choice. Thus, India has adopted a middle path in order to facilitate the growth of every citizen according to their liking. It is a thing antecedent to government. Government is established and governed under the constitutional principles. And then one more aspect which I would like to tell you is that, but at the time of framing the Constitution, the fundamental rights were framed among the carnage of fundamental wrongs at that time. Communal rights were there at various spots in the country, including Delhi, like Corona. Nobody was coming out. So the role of the press, all these things prompted the members to place more restrictions at that time and also to include the provisions of the preventive detention. One more thing which I would like to tell you, specific features of the Indian Constitution. India committed to international peace and security under the directive principles of the state policy. Similarly, specifically taking democracy to the grassroots, Panchayat Raj is specifically mentioned in the directive principles. Look at the comment made by Granville Austin, who has observed the constitutional developments like Sir Ivor Jennings. He is not an Indian, but look at the statement made by him. We are not praising ourselves. They have acknowledged. Our botheration is that we won't recognize ourselves. We pull the legs of the others, each other, but the others say, Granville Austin, everybody should read that. It is like a very interesting book. Indian Constitution, Cornerstone of a Nation. He said, the Indian Constitution is first and foremost a social document. The majority of its provisions are either directly or indirectly aimed at furthering the goals of the social revolution or attempt to foster the revolution by establishing the conditions necessary for the achievement. The core commitment of what? Social revolution lies in Part 3 fundamental rights, Part 4 directive principles of the state policy. He said they are the conscience of the Constitution. The fundamental rights and directive principles had their roots deep in the struggle for independence, as we have seen. And they were included in the Constitution with the hope and expectation that one day the tree of true liberty would bloom in India. That was the expectation. Did we make it to bloom? Even the foreigners expected, even after 70 years, still we are crawling instead of running. Okay. Now, there is one more angle which I would like to touch. That is, nowadays you must be hearing transformative constitutionalism. The judges themselves taking cue from one of the articles or works of an African, whether it is Navadeh Singh case or Joseph Shine's case, they have used the expression transformative constitutionalism. For the changing needs, you adopt the constitution. Even prior to it, there is constitutionalism. Constitutionalism means limited power or limitations over the power, because power corrupts and absolute power corrupts absolutely. And we have definitely constitutionalism in the Constitution. These principles, if you follow correctly, automatically the much talked about topic like good governance, we are thinking good governance is taken care of if you follow constitutionalism that is mentioned in the Constitution in the form of rule of law, separation of power, sovereignty of the people, independence of the judiciary, inviolability of the fundamental rights, and entrenched provisions. Now, my friends, Vishal Bera has recited the preamble. The expectations of the Constituent Assembly member, I am telling you, the preamble is the most precious part of the Constitution. It is the soul of the Constitution. It is the key to the Constitution. It is a jewel set in the Constitution. It is a superb prose poem nay, it is a perfection itself. The Pandit Thakur Das Bhargava in the Constituent Assembly has stated. In view of the time factor, once again, I tell you about the preamble and I will wind up. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and unity of the integrity of the nation. In our Constituent Assembly, the 26th day of November 1949, do hereby adopt and enact and give to ourselves the Constitution. But on 26th November 1949, we didn't have 2-3 terms, 3 words like socialist, secular, and integrity. They were added in the year 1976 by Constitution 42nd Amendment Act. Preamble gives you the scope for identifying goals and values of the Constitution and constitutionalism. All these things are facilitated through the preamble. Okay. What is a value? Suppose if you wanted to go to railway station or an airport, you will take several modes of transport. Auto, taxi, rail, all these things. Whereas, for your travel of the Constitution, to achieve the goal values, what are the goal values? Justice, liberty, equality, fraternity, assuring the dignity of the individual, and unity and integrity of the nation. We have opted for the vehicle of sovereign, socialist, secular, democratic republic. This is our vehicle. So these are the instrumental values and these are the goal values. You must understand that Indian Constitution, with seemingly minor changes, has changed the entire scene. Look at the decisions of the Supreme Court. I wanted to give all those things, but time is up, wherein I may not be able to talk anything more than that. Already it is 10:52. How much time is left to me? Hello?
Yes, sir. Sir, like you can continue for like 2 to 3 minutes more. Then we have question answer session also, sir, if time permits.
Then you can go for question answer session. They can ask, not even confined to this, they can ask anything. Okay.
Okay. Yes, sir.
I tell you that nearly half an hour situation is there. Nearly half an hour. Okay?
Yes, sir.
Why only you are shown?
Am I audible? I am Furkan from ILI. I am Furkan Ahmed from ILI. Am I audible?
Yes, you are audible, please.
Actually, because now I have listened a very big stalwart on the Constitution, and to whom I have already read. I think even not on the Constitution but constitutional history. So actually, what is your view? What is the position of various constitutional instruments today? How they are working? And what was the inspiration of the constitution makers and freedom fighters? Is there any, I think, little deviation from their stand or their feeling or the sentiment? For that we were used to, people said that sare jahan se acha Hindustan hamara. So actually I want to know your expert, because you are an ordinary student. For that, because of this feeling and since long, I think sare jahan se acha Hindustan hamara, this inspiration and feeling is already imbibed in our constitution by our freedom fighters and I think constitution makers. But today, how constitutional instruments are being run, what is your view? Because you are an expert, independent view.
Now I understood your problem. Now, what I would like to tell you is that the bare text of the Constitution, don't call it as bare act, okay? The bare text of the Constitution as we adopted, and then subsequent developments by judicial interpretation is different. Justice Chalameshwar, in K.S. Puttaswamy's case, he has used the expression constitutional dark matter. What is the dark matter? I would have been happy if some other expression is used. Okay. Namaste, Justice sir.
Namaskar, sir.
Some other expression is used. I have asked given Justice Chalameshwar about this. He has used the expression constitutional dark matter. There is what is known as secret constitution. Can you say that Article 14 is the same as that it was adopted in 1950? You can see that state shall not deny any person equality before law, equal protection of laws within the territory of India, provided that you will have to give explanation. Reasonable classification is permissible, and then provided that the action is not arbitrary. Sometimes they thought that these two are mutually exclusive, but not. And then you can also think of explanation about legitimate expectation, principles of natural justice, and Wellsbury principle. All these things were there at that time. Go to Article 21. The procedure, what was the interpretation given? Literally in 1950 in A.K. Gopalan's case, and what was the decision given in 1978 and afterwards? In the review or in deviating based upon Bengal immunities case and other cases, the court is of the opinion that if error is committed previously, it is not an error. At that time they have adopted literal meaning. Now they wanted a different meaning based upon changing times. After emergency especially. Professor Upendra Bakshi once said that Supreme Court got Democratic Republic expression only in 1978. Now they have got freedom to express themselves. So at that time that is different. And then what is the position during Corona? All the rights are violated or not?
Yes.
What you have? Legislations. In order to violate your fundamental rights, you will have to have under Article 19 some legislation to implement 8 prohibited markers. Every right is violated. What is the legislation you have? Disaster Management Act meant for something else is rather invoked because the meaning, rather definition of disaster is different. Epidemic Act 1897, now it is invoked. Your rights are violated. Section 144, Section 188. These are the provisions under which the judiciary has taken shelter and suo motu cases. Even though social media criticized it for rather taking into cognizance a bit late, from May onwards, how many suo motu cases are possible? That is why I said it stood the test of the times. Under Article 32, it can have the power. Under Article 142, complete justice, it can have the power.
Yes.
Supreme Court has the power. Supreme Court is endowed specifically. If you wanted to see the Constituent Assembly debate, you can see the statement of even Dr. Rajendra Prasad and others who have given them wide powers. Even though once you call it as court of record, contempt power is implied, they have specifically stated contempt power. Okay.
Yes,
Under
sir.
Article 129 of the Indian Constitution. The contempt power of the Supreme Court is different from that of the other court. Supreme Court is not bound by this, what is Contempt Act of 1971 or some other legislations, whatever it may be. Okay?
Yes, sir.
That is the thing. These are all the things which I wanted to discuss actually, but I made it in a simple form.
Thank
Already
you, sir.
I am exceeding. Our next speaker is waiting.
Yes, sir. We have among ourselves Justice Pinaki Chandra Ghosh, who is the Lokpal of the chairperson Lokpal.
I have seen him previously. Please convey to him and also Honorable Justice Gopala Gowda. I may
Yes,
not be able to attend their
Session.
for the reason that now I have to visit Hyderabad. After that, I may
Right.
have to visit another place. So please convey on my behalf. I am thankful to everybody who has given me this opportunity. Thank you very much, sir.
Thank you. Thank you, sir.
And my anchor and also the person who has invited me, Anushmi Jain. Thank you.
Thank you, sir. Thank you so much. Now I request Anushmi ma'am to kindly, with the permission of the Honorable Justice Pinaki Chandra Ghosh, sir, we should begin with the next event. Justice, sir. Lordship.
Good morning. Good Lordship is not available now. Good morning, Lordship. Lordship is a little busy.
Lordship, with the due permission, should we begin with the event?
Anushmi, you have got phone number?
Yes, sir. Vishal.
Please ring up. And
Yes, sir. Sir is joining in 1 minute.
okay, sir. Okay, good.
Hello.
Namaskar, sir.
Namaste.
Anushmi ma'am, with the due permission of the speaker, please, we should begin with the event.
Lordship, should we begin?
Hello. Can you hear me?
Yes, Lordship, you are audible, Lordship.
Okay. So shall I start now?
Uh,
Lordship, we would like to introduce you to the participants and then we should begin with the event.
Yes.
Okay, Lordship. Anushmi ma'am, can you please take over and just start?
Yes, sir. Good morning, everyone. I would like to take the privilege to extend a heartwarming welcome to our second speaker of the day, Justice Pinaki Chandra Ghosh, Chairperson Lokpal, former Judge, Supreme Court of India. Thank you, Lordship, for accepting our invitation and being with us today. Now, I would request Mr. Vishal Bera to introduce our speaker, Justice Pinaki Chandra Ghosh, sir. Over to you, sir.
Thank you so much, ma'am. A warm greetings to the chief guest of our day, Lordship Shri Justice Pinaki Chandra Ghosh. Sir, Lordship was born on 28th May 1952. Justice Shri Pinaki Chandra Ghosh obtained a degree of BCom from St. Xavier's College and LLB degree from University of Calcutta. Subsequently, he became at law at High Court of Calcutta. In July 1997, he was appointed Judge of Calcutta High Court. In 2012, he was appointed as the acting Chief Justice of Andhra Pradesh High Court and subsequently he became permanent Chief Justice High Court of Andhra Pradesh. In 2012, he served as the Chancellor of Nalsar, Hyderabad. In 2013, He was appointed as Supreme Court judge. From 29/6/2017 till 21/3/2019, he served as member of National Human Rights Commission, New Delhi. He has been appointed as Honorable Chairperson Lokpal on 23rd March 2019. We welcome you, sir, and the mic is over to you, sir, for the next session. Thank you so much, sir.
Thank you and good morning to everyone who are present here. I am really indebted to the persons who have requested me to give a speech on this Constitution Day. I must tell you that where from this Constitution Day and why this was adapted. This was really adapted by the Indian Constituent Assembly on 26th of November 1949, 71 years before. Since then, every year, this day is celebrated as the Constitution Day in India. And in fact, after 30 years of November 26, 1949, the Supreme Court Bar Association declared this day as a National Law Day. We are celebrating as Law Day throughout India since then. It is celebrated in honor of the 207 eminent members of the Constituent Assembly who contributed to the Constitution of India. The subject of today's dialogue is constitutional morality as a challenge in India. The Constitution of India is a source of moral guidance to our courts in deciding various facts and the issues on the basis of the said facts. From time to time, we have seen the overreach of judiciary, people are saying, but in fact, when the matter comes before the court decides the matter on the basis of the facts placed before the court. So overreaching, or whether it was not overreaching, that cannot be decided at this stage until and unless that can be decided in some other matter, and that should be also decided by the court of law. The doctrine of the constitutional morality is relatively recent addition, which is time and again provoked by the Supreme Court in past rulings by delivering landmark judgments. The doctrine of constitutional morality is a form of judicial activism, so to say, in some matters. Constitutional morality is not defined anywhere. Even if we search, we can't get that definition of constitutional morality. There are different notions on the same. It means adherence to noble principle enshrined in a constitution, principle interpretation of the constitution in line with the ethos of constitutional democracy. It may also be defined as adherence to core values of principles and philosophy of constitutional democracy that extended to create egalitarian moral society based on social, economic, and political justice. Constitutional morality is the concept which commands and empowers the judicial minds to interpret the Constitution and its provisions in a moral way, subject to the Constitution and not to the public morality. The concept of constitutional morality was first propounded by the British classicist named George Grote in the 19th century in his book, A History of Greece. In Grote's formulation, constitutional morality meant as under that all citizens would respect and adhere to the Constitution. No one would disobey the authorities acting under the Constitution. All citizens would have the unrestrained freedom to criticize public officials acting in discharge of their constitutional duties. All public officials would have to act within the domain of the Constitution. All the contenders for political power would respect the Constitution and know that their rivals also respect the same. In India, constitutional morality was first propounded by Dr. B.R. Ambedkar on 4th of November 1948 in parliamentary debate to inculcate the morality in the Constitution with its great importance and effectiveness. While addressing the said quoted Grote's word that constitutional morality was not a natural sentiment and said that Indians have yet to learn it, according to Ambedkar, constitutional morality was not to be used by courts to invalidate legislation of government action. Simply, he used the Grote's idea as a persuasive or rhetorical device to justify why seemingly mundane details about the administration of the government had been in Constitution of India. In Ambedkar's view, constitutional morality means an effective coordination between conflicting interests of different people and the administrative cooperation to solve issues or conflicts amicably or in friendly way as far as possible. In Dr. Ambedkar's perspective, constitutional morality would mean an effective coordination and between the interest conflicting of different people and the administrative section who are amicably without any confrontation amongst them comes to the conclusion and ends the difficulties between those at any cost. The moral fabric of the society, according to Ambedkar, governed and the governance must be strong. In other words, public conscience, moral order, and constitutional morality, ethics of politicians that constitute the core of policy making must be very sound and strong if democracy is to survive for long period of progress and prosperity for the common people. Thus, constitutional morality is not limited only to following the constitutional provisions literally, but vast enough to ensure the ultimate aim of the Constitution. It is so broad that it includes commitment to inclusive and democratic political process in which the individual and collective interests are satisfied. A judicial scenario providing an opportunity to unfold the full personhood of every citizen for whom and by whom the Constitution exists. It specifies norms for institution to survive and an exceptional behavior that will mirror not just the text but the soul and spirit of the Constitution. It means practical percolation of constitutional values in governance and citizens' entitlement requires a sensitive state apparatus. The judiciary, as an interpreter of the Constitution, has effectively used constitutional morality to overcome age-old laws, which needs to get reformed with changing time. As society can't be static, it gets evolved with changing times. Same goes with the law to cater the needs of the society by keeping in mind the spirit of the Constitution. So to say, the elements of constitutional morality, according to me, includes rule of law. Mostly I say the rule of law, individual liberty, second, right to equality, freedom of choice of expression, then the preamble of our Constitution that has to be in the mind, then social justice and due process of law. Everything has to be done with due process of law. Till 2010, the phrase constitutional morality, now I am coming to the judgments of the Supreme Court and trying to find out that the phrase of that constitutional morality used by the Supreme Court in less than 10 reported cases from the time of the Constitution was adapted. But in recent time, in the year 2018 alone, we will find it has been used in more than 10 reported cases by the Supreme Court. The first time it was referred by the Supreme Court, as you all know, in the known case of Kesavananda Bharati versus State of Kerala and another in the year 1973. Then the judgment of S.P. Gupta versus Union of India, which is known as first judge's case, observed that violation of constitutional convention would be a serious breach of constitutional morality. And then Justice S.B. Sinha held that affirmative actions might be valid, but it would violate constitutional morality if it is not in consonance with the doctrine of equality. So we have seen that till that date it was taken at least thrice, 73, 81, and in 2003 by the Supreme Court. But we have observed in very recently, as we have found that constitutional morality is reiterated by the Supreme Court in many landmark judgments, as it was stated by the Honorable Justice Deepak Misra, as his lordship then was. I quote, "The magnitude and sweep of constitutional morality is not confined to the provisions and a literal text which a constitution contains and a literal text which a constitution contains, rather it embraces within itself a virtue of a wide magnitude that ushers in pluralistic and inclusive society," unquote. The doctrine is an emphatic guarantee that court plays a counter majoritarian role within constitutional scheme, and it is committed to protecting all minorities. There are many landmark judgments of the Supreme Court of India wherein the doctrine of constitutional morality is applied. I would only quote few of them which should not go out of our mind. Navtej Singh Johar versus Union of India, which deals with the protection to the rights of the LGBT community. The Supreme Court came up with the judgment which partially struck down Section 377 of IPC, which made colonel, etc., and as a not a crime. Then the Supreme Court held that constitutional morality cannot be portrayed at the altar of social morality, and it is only constitutional morality that can be allowed to subsist and to bring into the rule of law. The veil of social morality cannot be used to violate fundamental rights of even a single individual, for the foundation of constitutional morality rests upon the recognition of diversity that pervades the society. I have also seen, and I'm quoting now, that in the Joseph Sain versus Union of India, also very recent in 2019, upholding the right of gender equality and right to equality, the Supreme Court struck down the Section 497 of the IPC, which made adultery a crime for a man, etc. But here the court noted that the constitutional validity of criminal laws not to be determined by popular or public morality, which are not in consonance with the constitutional morality. The idea of husband as a master of woman, or a woman as a possession of her spouse, was held to be completely contrary to the spirit of constitutional facets of ideals. Here the doctrine of comes as counterpoise to public morality. That is the opinion expressed by the Supreme Court in that judgment. Then we have found that Indian Young Lawyers Association versus State of Kerala, as all of you, this is the latest one, and the judgment which really gave a biggest blow on public morality and also criticized by religious prophets and others. The Supreme Court held that exclusion of the women between the ages of 10 to 50 years from entry into Sabrimala temple for worship of Lord Ayappa was violative of Article 25 of the Constitution of India. The same principle was used by the court in the Triple Talaq case also. The Supreme Court noted that the word morality in Articles 25 and 26 must mean constitutional morality and not popular one. The Supreme Court observed, I quote, "The existing structure of social discrimination must be evaluated through the prism of constitutional morality. The effect of the endeavor are to produce a society marked by compassion for every individual," unquote. There is minority decision, as we have seen, the opinion expressed by His Lordship, Justice Malhotra. In the above backdrop, a 9-judge constitution bench of the Supreme Court, headed by the Honorable Chief Justice of India, is seized of the matter which involves the determination of the 7 issues framed by it which pertains to religious freedom in India vis-a-vis individual rights and group rights. Moreover, the Supreme Court is tasked to come up with a uniform and standard judicial policy and precedent with which matters specifically related to religious freedom vis-a-vis individual freedom could be adjudicated in the coming years. Is a progressive, whether it's in the government of NCT of Delhi versus Union of India in the year 2018, this judgment again reiterated the doctrine of constitutional morality. The issue is to figure out how power is to be shared between the central and the provincial government of Delhi under the constitution. It was unanimously held by the Supreme Court that the chief minister and not the lieutenant governor is the executive head of the government. The court noted that morality is constitutional norms and consents of the constitution. Now, if we critically analyze all this, the doctrine is not only restricted to some text of the constitution, it is in the spirit of the constitution. It requires in a democracy the assurance of basic rights which are essential for existence to every member of the society. The doctrine is a counterpoise to public morality, and also it is a facet of basic structure of constitution, which provide judiciary a power to keep check on the spirit, meaning that by the soul of the constitution by taking a step ahead, then purposive and literal interpretation. We have seen that the doctrine is a progressive approach to change of time and evolution of society. But are there no demerits of that doctrine? That's a question I'm putting to all of you. We'll know each coin has two faces. Same is with the doctrine. The constitutional morality is nowhere located in the constitution, and it is necessary to do the same, as there is evident danger that might concept be used in constitutional courts as per the whim and fancies of the brains, judicial brains, as in absence of definite clarity and consensus being reached on the doctrine. The objective of doctrine is to preserve the rule of law and also not to act in a manner which in violation of a provision of constitution or arbitrary in any manner whatsoever. When we refer to judgment in which it was used, each one connotes a different meaning, has resulted in confusion that actually what is the doctrine is. For an example, when we see the dissenting note of a judge, honorable judge, in a case, it is also based on the same doctrine, but with different interpretation for allowing the ban or not allowing the ban, while the same concept was used by some other honorable judge who will not permit it to have that ban, as this is holding that this is nothing but discrimination. It is only depend upon the two persons to persons, it varies on the basis of their perception and conceptions of law. Therefore, there cannot be a straitjacket formula in any manner in respect of a doctrine which has come to the conclusion by the Honorable Supreme Court. So we have to go by the order and the judgments already on record passed by the Supreme Court, and we shall take that as the soul of the Constitution which has been enacted by the Supreme Court. But I must tell you that the unbounded judicial creativity makes the court day-to-day. Constitutional convention and the purpose of separation of power will be defeated, as judiciary always can establish its supremacy over legislature by this type of crafted inventions. The question here is, are we now headed into uncharted territories where we are going to see more conflict and more confusion And what brings more clarity? The answer will be time to come to answer for the same as and when it will come before the court, and the court will decide the matter. Dynamism of constitutional morality has to be understood in proper perspective. It expects the constitutional authorities to act within the four corners of the Constitution. Similarly, if there is any kind of practice which is not in conformity, then holistic application of doctrine can be used, not in a narrower manner, but in a broader manner, and to solve the problem. Every public policy decided on the ground of this doctrine. It's absolutely within the constitutional paradigm. It's not an uncharted plan. We have seen the Sabarimala judgment of 2018. We have also, there are so many debates, etc., and comments were made. But the analyzing all these judgments as I have quoted before you, rather I have cited those judgments before you, one thing becomes amply clear, that the silences of the Constitution are also to be ascertained to understand the Constitution. Constitutional morality is this silence of the constitutional text regarding which, in the judgment of Justice K.S. Puttaswamy, Supreme Court has stated, where right to privacy was elevated to the status of a fundamental right. Liberals and progressives have lauded the Supreme Court for espousing this progressive approach. However, at the same time, on the opposite end of the ideological spectrum, many among those who rail against liberals claims that the application of this doctrine amounts to judicial overreach and are thereby pitting constitutional morality against societal or popular morality. I do not want to make any further comment, but sometimes I have found that even the renowned lawyers has observed that the constitutional morality is a dangerous weapon, as the courts have applied it subjectively. But we cannot forget that the purpose of the Constitution to give effect to the soul of the Constitution, the court, that's the reason, cannot forget about the spirit of the Constitution, which would come from the core of the hearts of the judges who are deciding the matters. I have also read one book written by the senior advocate Abhishek Singhvi, From the Trenches. The name of the book is From the Trenches in 2020, which commenting on constitutional morality, specifically in regard to the Sabarimala case, argues that this phrase is full of subjectivity. He maintains that the judicial approach of constitutional morality could vary from judge to judge. I do not want to join any issue with anything now at this stage. It's not proper for me, because I have also presided over the bench in Supreme Court. I have a great respect for that court, and I cannot say anything else, excepting I would say that as rule of law is not explicitly mentioned in the constitutional text, still it is not just part of the Constitution, but also the basic structure. However, I must tell that the two grounds we always try to keep it our mind as being done by the apologists of social morality. One is first premised upon the wrong presumption that constitutional morality is for the matured society, and this is possibly a superficial understanding of the issue. And second, the courts are not the appropriate fora to adjudicate upon these issues, where also I want to join issue, because the court has power, and court, after taking into account of all the aspect, including the social fabrics, decides the matter. Therefore, the argument which tried to be made by the apologists of social morality with the constitutional morality, I cannot accept those rather questions raised by them. But however, giving a leeway to social morality at the altar of the constitutional morality in a highly religious and diverse nation as India is, can embolden the whoever is majority in the matter. However, according to me, it is the rule of law which should be the order of the day, and not the social morality alone and enabler of the majority. It should therefore be sparingly used while interpreting the constitution. However, if the present thing cannot be accepted, the court will decide the matter. Significantly, in all other matters, when the court has already decided the question, I do not intend to say anything further, excepting I would say that court always, as has been done, and express their views, taking into the consideration of the social fabric. I believe that should be the proper way. And despite the presence of several precedents of judgments based on the principle, there is no fixed definition. I have to accept that has been attributed in respect of the definition of to constitutional morality. So I will say another viewpoint presented by those in opposition to the doctrine of constitutional morality is that it hinders the organic and natural development of liberalism or rectification of the wrongs or ethical ills of the society, as it vests powers in the hands of the courts to implement a top-down approach of the ideal on morality front. Some have supplemented this proposition with the corollary premise that it indirectly reflects a lack of faith on the true ideals of the democracy, which is based on the wisdom of the populace that is to be governed. One strong argument against the existence of constitutional morality also cropped up as a judicial principle is that it is in clear violation of a very basic tenet of democracy, that is of separation of power between the three wings of the state governance: judiciary, legislature, and executive. Dissenters keep pushing forth the idea that the projected objective of upholding and promoting democracy by using constitutional morality is merely a sham, as it establishes judicial supremacy and excess activism by the courts, leading to the intervention in those functions which are primarily sanctioned to be undertaken by the legislature. At the end, I would like to say that the only thing we must keep in our mind that rule of law is nothing but coming out of the law framed by the parliament, and could always try to keep track on that and passes an order based on that. At the end, the celebration of this National Law Day is essential, since we become aware of what values our predecessors wanted to instill in us. Let us on this Law Day rededicate ourselves to serve the society, particularly the poor and disadvantaged sections, to ensure equal justice to all and strive to provide speedy and less expensive justice. I thank the organizers for inviting me and giving me a chance on this occasion to tell you something. And thank you to each one of you. Thank you.
Thank you, Lordship. It was indeed a pleasure, Lordship, hearing you. Lordship, with your due and kind permission, should we take up 3 to 4 questions which have been put up by the participants, if your Lordship permits, sir?
usually law में no questions or
No
answers
questions are raised actually, Lordship.
will be allowed. But even then, I like to interact. There is no difficulty. But I would not answer any question which is the matter is pending before the court or court has already passed an order in the matter.
Absolutely, Lordship.
Because I have already
Absolutely.
pointed out what are the laws has been already laid down by the Supreme Court, right?
Indeed, your Lordship. Indeed.
Okay.
Ji, ji, ji.
So, indeed, Lordship, should we begin with the question?
Yes, please do that.
Thank you. Thank you, Lordship. Lordship, the first question to you is that, Lordship, how to ensure true spirit of constitutionalism and popularize it in India?
Now you see the constitution has specifically stated everything, whatever is within the four corners of the constitution. Any matters come before the court, either for the violation of the constitutional rights which have been given to the citizens of India. So court always deals with that, taking into account, and the other law which is connected to the rights of the people, meaning they are the citizens, which is being affected by any action on the part of the I will say the government straight away, because the most of the cases filed against the government.
Thank you, Lordship. Lordship, the next question to you is from Professor Bhanu. He wants to ask that what are the actual problems of constitutionalism? What are the actual problems of constitutionalism?
After presiding over the bench for such a long time, shall I answer that?
So that is your obligation, Lordship.
Because I must tell you very frankly, whenever the matter comes before the court, as a judge, he is also a human being, as I also was there. So we, according to our own whatever, our thinking, our knowledge in law, then after reading everything, then we come to the conclusion, no.
Indeed, your Lordship.
So how I can say that if there is some wrong, etc., when it has been done by the persons after applying his whole thing in the matter in question.
Indeed, Lordship. Lordship, we will take only two more questions for the day. The second last question for the day, your Lordship, is that what should the rest of the world learn from the Indian Constitution towards the approach to secularism, Lordship?
To the approach of
Secularism.
secularism.
What should the world learn from India?
Now, this secularism, is there any meaning of that secularism definition you can get out anywhere?
No, Lordship. No, Lordship.
You won't get that.
Doesn't have a definition.
But the India, as you have seen that earlier also, that we usually, there is no bar in respect of any person to come and stay here in accordance with the provisions of our law, which is everywhere. There is some problem was created somewhere, some days, we don't know. But at least we can say before the present before the world that the democracy is being done here and which is largest of the world. Isn't it?
Indeed, Lordship.
Yes, sir. Yes,
Indeed. So, Lordship, and the last question, Lordship, to brief you that I am taking a paper, Lordship, that is named Lokpal Lokayuth. I am teaching a paper in 5th year. So, Lordship, I have a question in mind which relates to the Constitution as well, Lordship. So, the question is that how corruption actually undermines the morality of the Constitution.
Morality of the
Constitution, how corruption undermines the morality of the Constitution. Because, Lordship, we see the Ombudsman is a watchdog of the administration. So then how corruption is actually undermining the morality?
Now, have you seen the new Lokpal Act?
Yes, indeed, your Lordship, indeed.
Do you say it is only watchdog?
No,
Do you
sir.
suggest that?
Before it was, but now it is not, Lordship.
It is not a watchdog. It can hound, it can bite also.
Bite
Yes,
also.
yes.
By the section 11 and 12,
Because,
your
yes,
Lordship.
if you see that the power is there, we can take anyone from anywhere and appoint a seat, meaning by the investigation team, and to investigate. And after the result of the investigation comes, the FIR will be lodged, and that will be also placed before the court, and the court will deal with the matter. That it has been specifically stated in the section, and those courts are just like the Lokpal courts. You will find
Yeah,
out
yeah,
the
yeah.
Lokpal can create the courts also.
Yes,
So-
indeed, Lordship.
Yes, so therefore teeth is also there.
So the Lokpal is all under your hands, Lordship. The teeth is under your hands now.
We are trying. We must tell you very frankly, because of COVID, as you know,
Yes,
was
indeed,
a
Lordship.
bit of. But our rules have already framed. We have already taken up the matters. Matters are coming, but the people are not really known about what is the whole clear picture to them, that because they are coming for whatever and everything with regard to their difficulties before us. So we are only giving them opinion also. You can go do this, you go there, you do this or do that, including service matter, pension matter, all these matters, they are coming, including asking for some job. Give me a job.
So the public is not actually aware of the Lokpal court, your
Yes,
Lordship.
that is the reason we shall hold meetings, etc., so that it can be go to the veins of the people of India, and they can know what is to do and what not to do. But
Indeed,
in our
Lordship.
website, we have already specifically stated how you can come, what should be what is the way you can file your complaint. The rules are there. Everything we have given. So that is the only thing.
Thank you, Lordship. Lordship, with the due permission, should we end up with the questions?
Yes, please.
Thank you, Lordship. Anushmi ma'am, over to you.
Yes, sir. Thank you, Lordship. Thank you for answering all the questions. I would now call upon Mrs. Monica Kharola, Academic Coordinator, to deliver vote of thanks to sir. Ma'am, please.
Ma'am, you are not audible. Monica ma'am.
Madam, we are not audible.
Ma'am, you're not.
Please unmute yourself.
Ma'am is already unmute.
But then why she's
Anushmi ma'am is gone there.
okay? Vishal, you go ahead with the vote of thanks.
No, ma'am is already there. Ma'am will be audible in a while, sir.
Okay, okay.
Lordship, due to a bit pause of time in the beginning, I apologize to not introduce our respected Dean, sir. He's Professor Dr. Yugal Kishore. He's the Dean of ICFI Law School.
Okay. Thanks to all of you. Thank you.
Very kind of you, sir.
So I would
We
like
are
to
in- sir.
to Justice Pinaki Chandra Ghosh, who was kind enough to spare his valuable time and come and discuss the importance of constitutional morality to all the participants. So we are thankful for your opinion which you have given. You have been on the bench for so long, and you have very nicely deliberated on the role and how the society must progress. Thank you for being with us. And once again, we would love to hear from you if you are free in the coming days. Thank you, sir.
Namaskar, sir. Namaskar, sir.
Namaskar.
Namaskar, Lordship. Namaskar, Lordship.
Thank you, Lordship.
Thank you.
Thank you, Lordship.
Now I request all other participants to please remain in the event, as after 5 minutes we're going to start with the next session, which will be presided by Justice Venkate Gopala Gowda. So I request participants, and we give a 5 minutes of break to all the participants as they have been continuously being present from 9:45. So we just take a 5 minutes break in the session, and then we're going to join at 11:50. The meeting will not stop. The same platform will be available, and we'll start at 11:50. Yes, okay, sir?
Okay, it's okay. Sure.
Anushmi ma'am, I shall coordinate with the speaker, and we should start at 11:50 after the Justice Saab joins.
Okay, after 5 minutes, I will be here.
Okay, okay, sir.
Okay.
Okay, sir. Ma'am, just keep the tap on the participant list when the Justice Sir joins.
Anushmi sir has joined. Our Lordship has joined.
No, sir, not yet. He'll be joining in.
Oh, no, you're not audible.
No, sir. No, sir.
You're not audible.
Sir, am I audible now?
Okay.
Uh, am I audible now?
Hey Ram.
Ma'am, I think Lordship is having some network connectivity issue. Just try to help him once.
Yes, sir, sure.
Just call him up once and just try to.
The number you have dialed.
Okay.
Having some network connectivity. We just need 5 more minutes. Whether he can join or not, he's having some network problems, sir.
Okay. So we'll wait for another 5 minutes.
So,
No problem.
so because he's in down south and there has been some cyclone in South India, sir.
Let us wait if he's
Yes,
capable
sir.
of joining on it, otherwise we'll postpone it. We'll
Yes, sir. Due to some cyclone and rain problem, he cannot join, sir. Means having network problem, sir. I just spoke to him, sir.
So will he be capable of joining or not?
So I'm speaking to his PA also. He's just trying, sir. He's trying, sir.
Okay, if he's capable of joining, all right. Otherwise, we'll do it some other time.
Okay, sir. I'll just trying, sir. We are trying, sir.
Yes. Very good.
Lordship has joined, ma'am. Anushmi, ma'am. Lordship, sir has joined. Akhilesh, sir, please make Lordship the co-host.
Dean, sir.
Please, Akhilesh, sir. Lordship, we made you the co-host. You can unmute yourself. Dean, sir, we have Lordship with us.
Sir, you are on mute. Dean, sir, you are on mute.
Lordship, namaskar. Lordship, namaskar. I'm Professor Yugal Kishore, Dean here.
How are you?
I'm good, sir. Because of your blessings, I'm
How are you?
right. I'm good, sir.
Very good.
How are you, sir? How
I'm
is the cyclone there, sir?
Yes, good.
Acha.
Okay. With the due,
And 5 minutes. 10 minutes.
Ji.
yes, sir. With the due permission of the Lordship, should we begin with the event?
Please proceed.
Anushmi, ma'am, should we begin?
Much obliged, Lordship. Much obliged.
Obliged, Lordship.
Something wrong, huh?
Now, moving towards the next session, I would like to take the privilege to extend a heartwarming welcome to our third speaker of the day, Honorable Shri Justice Venkat Gopal Gowda, former Judge, Supreme Court of India. Thank you, Lordship, for accepting our invitation and being with us today. Thank you so much. Now, I would request Mr. Vishal Bera to introduce our speaker, Honorable Shri Justice Venkat Gopal Gowda, sir. Over to you, sir.
Thank you so much, ma'am. First of all, welcome to our chief guest of the day, that is Honorable Mr. Justice V. Gopala Gowda. We welcome you, sir. Sir, Lordship was born on 6-10-1951 at Pedur, Chikkabalapur district in Karnataka state as son of late Sri D. Venkade Gowda and Srimati Subhamma. Lordship did his BSc from first grade college Chintamani in 1971-72 under Mysore University and LLB from SJRLC Bangalore in 1975. Lordship enrolled as an advocate on 14/11/1975 and joined the chambers of Sri K. Subbarao and Sri S.C. Reddy, Senior Advocates, Bangalore. Lordship started his independent practice from 1979 at Bangalore in the High Court, Labour Court, Industrial Tribunal, Civil Courts and Criminal Courts and handled constitutional matters, writ petitions and cases relating to labour, service, civil, cooperative society matters, land reform, criminal matters, matrimonial and all other civil matters. Lordship appeared for various and several trade unions, and Lordship was also a part-time professor in V.V. Puram Law College from 1983 to 1991 and taught some specialized subjects like Mohammedan law and labor law. And also he was a part-time professor at the University Law College, Bangalore in 1986-1987. Worked as Standing Counsel for Bangalore Mahanagarpalika from 1983 to 1993, and again in 1995 he was elevated as the Additional Judge of Karnataka High Court and also as Standing Counsel for Karnataka Public Service Commission, Bangalore. Lordship was a member of Karnataka State Bar Council and Chairman for Enrollment Committee till elevation as Additional Judge of Karnataka High Court. He was then elevated as Additional Judge of Karnataka High Court on 11/6/1997 and became a permanent judge on 3/6/1999. Also, he functioned as the Executive Chairman of Karnataka State Legal Services Authority, appointed by His Excellency the Governor of Karnataka with effect from 23/6/2006 to 23/3/2010, and also as a member of the National Legal Services Authority, New Delhi from 7/1/2009 to 6/1/2011. Lordship was sworn in as the Chief Justice of Odisha High Court, Cuttack on 25/3/2010. Then Lordship was elevated as a Judge of Supreme Court and assumed charge on 24/12/2012, and Your Lordship retired as a judge from the Supreme Court of India on 5 October 2016. We welcome Lordship on this auspicious occasion of National Law Day. Over to you, Lordship.
What do you, Lordship? Sir, that is yours. Lordship,
Yes.
J.
Respected the director of the university, respected the faculty members, professors, my affectionate and loved students, it's a great privilege for me to be, I should have been in your midst today. Because of the world over pandemic, doctor's advice, I am unable to travel to Uttaranchal to be in your midst physically.
J.
Pardon me. Nonetheless, it is a happiest occasion for me to be in your midst through video conference. Today is a very, very, very important celebration of Constitutional Day in the entire country, particularly universities like yours. A meaningful celebration of 71st Constitutional Day being organized by your university to bring home the point to the students community that we have what vibrant constitution which was written and accepted by the Indian Parliament, Constituent Assembly on 26th January 1950. 26th November 1949, this was accepted, has come into force from January 1950 when we became republic. The constitution in the entire world, Indian constitution is a vibrant constitution. But the rulers of this country, either the central government or state government or local self-governments have failed to achieve and implement the constitutional aspirations by rendering justice to the people of this country. On this occasion, from bottom of my heart, I wish each one of you and citizens of this country across the country, I wish them to secure the aims and objects of the Constitution, particularly which are laid down in the preamble of the Constitution. And Part 3 and Part 4 both constitute the human rights to the people of this country. Then only the country will further progress and develop, and that's how we can get justice to each one of the citizens of this country. My dear friends, the credit must go to Dr. Ambedkar. He is the great architect of this constitution. He has studied the constitution of the world to draft vibrant constitution of India, particularly the preamble, part 3, part 4. Preamble aspects the concepts of sovereignty, the secularism, the sovereign socialist secular democratic republic India. Each phrase has got its philosophical content. We must remember this. Not only the faculty, students, the Prime Minister, the ministers of Council of Ministers of central government, the chief ministers of the whole country, the cabinet ministers of each state legislative assembly must understand the governance of the people is under the constitution. The constitution governance is not there in that state or in that country, in India, there will be violation of rule of law. A rule of law is the basic structure of the constitution, is what is said in Keshavananda Bharati's case. So if rule of law is governance under the constitution, so therefore you the students must understand that you must be wedded to the constitution. We are in a parliamentary democracy. The parliamentary democracy, there are two types of democracies. One is parliamentary democracy, of which we have got now. Another is the people's democracy, that is what is in the communist regime. After the revolution in USSR and China, it is the people's democracy in India where the representatives representing the parliament, legislative assembly, and the local self-governments like municipality, village panchayat, municipality, municipal corporations. These are all local self-government. After the 73rd and 74th Constitutional Amendment, which have come into force with effect from Part 9 and 9A, Schedule 10 and 11 have been engrafted into the Constitution to get justice to the people of the country. More particularly, the positive justice. The positive justice to see that they must be brought to the mainstream to live as citizens, as human beings of this country. That's why the phrase, the sovereignty, has got very, very important role to play in electing the representatives to represent them either in the parliament or in the legislative assembly or in the local self-government. Please remember that the democracy, sovereignty and democracy go together. It has got interrelated interrelationship. So now we are seeing the population of this country, the recent elections in Bihar, the recent by-elections across the country, it is not beyond 50%. That means principles of the Constitution. As a citizen, you have got a role to play. You are a voter. You have to participate in the democracy. Participate in the election. You must go and exercise your vote. If you don't exercise your vote, how can you elect your true representative to represent you in the parliament and the assembly? If a true representation is not there, how can you call it is a true sovereign country? The sovereignty depends upon the participation of the people of this country, particularly the citizens of this country. How can you protect the citizenship? How can you protect the justice? How can you give justice to the people? What kind of justice? Justice is also held to be the basic structure of the Constitution. What is the justice? Justice is social, economic, and political. To whom? Social, economic, and political justice to the people who have been exploited for ages. India has got 5,000 years old history. These 5,000 years, on the basis of the classifying the people on the nature of work, the people have termed as for the class of persons on the basis of the job. Who are you to give and classify? Classification is on what basis? What is the basis for you to classify the people on the basis of the caste? Who asked you to create the caste? From where did you get the caste? Where was it emerged? How it emerged? All people are equal under the Constitution. All people are equal. How can the caste system and all religions are multi-religion country, multi-religions are respected. Each religion is entitled to practice the religious tenets to other religion. You can persuade them to accept the religious tenets to accept another religion. That is why it is a secular country. It's a secular means secularism is defended before the Constitution has come into force in this country. Swami Vivekananda in Chicago, when he went there, the Constitution was not there. He said that there must be the patience of all the irrespective of the religion. One religion people, another religion must be respected. Where is it happening in this country today? And if it is not happening, who is responsible for this? If you are not responsible to protect the religion of another religion, how can you say that you are a democratic country and how can you govern the people? Are you entitled to continue in your office? Can you tell this? One parliament member says that pseudo-secularism. What do you mean by that? Is it the word kind in the preamble of the Constitution? Are you above this judgment of Supreme Court in Keshavananda Bharati, secularism, subsequently in Bommai's case 94 in election matter, they have said that secularism is the basic structure of the Constitution. The basic structure of the Constitution shall not be amended is the judgment of the Supreme Court. If that is the judgment of the Supreme Court is binding on you, more particularly the parliament member, are you going, what is the authority to tell irresponsibly in the public that we are going to amend the Constitution? The pseudo-secularism. Who are you to tell this? Who told you to tell this? Who authorized you to tell this? So these are the things where my students and my professors in the universities must tell the people, educate the people, bring home the census of this case. The secularism, the philosophy, and the conceptual ideas shall not be meddled with by anybody, including 542 parliament members. Mind you, this is what the Constitution, this is what Ambedkar has given to us. Successive governments have failed. in rendering justice. India, both the central government, state government, and the local government, under the scheme of the constitution and the ideals of the constitution. So equality concept is provided in Article 14 of the Constitution of India. Article 14 envisages equality, equal protection of laws. It is not equality to one particular religion. Equality irrespective of the religion to the citizens of this country. Not necessarily citizens of the country. Non-citizens also Article 14 is applicable. That's the concept of constitution in this country. These people must understand it when they amended the Citizenship Act of 1955 in the year 2019. That is the question which requires consideration in the Supreme Court. That matter is languishing in the Supreme Court. This most important aspect where citizenship consents to the whole, not only one particular Islam religion. It is in relation to the citizenship declaration. Citizenship you must prove. You must get the certificate of citizenship from the registrar of the births and deaths. He is the registrar under the Citizenship Act. That is what is provided under Section 14A of the Citizenship Act. Citizenship Act is amended in the year 2002. Rules have been made prior to 2002 has come into force in 2004. 14A rules have been framed 2003 before Section 14A has come into force to get the citizenship declared. What is this? Supreme Court, in Umai's case, 9-judge bench, this constitutional bench has ruled on the basis of the religion, no law shall be enacted. This is the law. This is the binding law, precedent, under Article 141 of the Constitution of India. How can you amend the definition of the illegal migrant? Illegal migrant, who are preventing you to persons who have been in Pakistan, in Afghanistan, in other countries, if minority religion in those countries, who may be the majority religious people, if they have been harassed, if they have been victimized, these are mentioned in the Citizenship Act of 1955, they are not illegal migrants, they are citizens. You can confer citizenship. Who will prevent you not to give citizenship to other persons? Rohingyas have come here. They are minorities. They have come here. They have sought asylum. We have minority Muslim community in Pakistan not to give citizenship to them. Ahmadiyas are victimized in Pakistan. Is a matter of record. Why are you differentiating? Why are you discriminating them? And you are telling that minorities in that country, other than the Ahmadis, can be conferred citizenship. Citizenship, you amend the Citizenship Act. Citizenship Act is enacted by the Parliament in 1955. Part 2 of the Constitution of India deals with the citizenship. Section 5, Article 5, Article 6, Article 11 is the basis on which the Citizenship Act is enacted. If that act is enacted, now that must pass in conformity with the provision of the Constitution. It must pass the test of Article 14, excluding the other minority religion people in that state. In Kathmandu, Sri Lanka, you are excluding the Tamil people to come here. Settlement had taken place even prior to that. And you are excluding those people from Sri Lanka. Is it not violation of Article 14? Article 14 can be pressed into service by non-citizens. That's the law. So therefore, today while celebrating the Constitutional Day, we must understand law which will be enacted. Either it may be the Citizenship Amendment, Citizenship Act Amendment, or in other states, in Uttar Pradesh, in Madhya Pradesh, the other states, people are talking loudly. We are going to bring the law imposing punishment of 10 years and fine if interreligion people are going to marry. They bring under the jihad, love jihad. What is this? Is it constitutionally valid law? Are you going to suppress the rights and take away the rights given under Article 14? Are you going to declare the rights given under the Indian Majority Act? After 18 years, it is the major, they can enter into any marriage with any religious persons? Is it permissible for you? Is it within the legal legislative competence, either under Part 2, 7th schedule, list 2? Where do you get this? To infringe the fundamental rights of Article 14, Article 19, Article 21. Will it not affect these 3 rights at least? And a statutory right given under the Majority Act? Are you going to take away the rights? How can you take away the rights? Fundamental right? What is the reasonable classification? Human rights of the people of this country? These are all the things which are protected by Dr. Ambedkar. Preamble, Part 3 and Part 4 of the Constitution of India. I am appealing to the students community who are large number present here. I hope that they are listening to my speech, that these are all the parameters, these are the basic features of the Constitution of India. You can't touch that. You can't meddle with the human rights of the people of this country. Justice. What kind of justice? Social, economic, and political justice. Whom that has to be given? People who are economically disadvantaged. People who are not in a position to get education. People who are not in a position to get employment. People who do not have the land, which is a material resource. People who do not have the public employment. For them, you have to take affirmative action of providing reservation. Make the tenants as the tiller as the tenant and the holder of the land. The land is a material resource. The water is a material resource. And provide all financial assistance to the people belonging to the economically disadvantaged, irrespective of the religion and the caste in this country. That is what is provided under Article 15 and 16. 15 and 16, not only that, reservation even in the local self-government, reservation to the parliament seat, reservation to the legislative assembly, chairmanship of the local self-government, reservation is provided. That is not sufficient. Millions of people are without land. Millions of people without house. Millions of people don't have employment. They are starving. In Delhi, in North India, during this winter season, for want of shelter, for want of the accommodation, for want of the clothing, people will die. Hundreds of people will die. Who is responsible for this? It is the government responsible. Governments are responsible for this. Constitution protects, but implementation has not been done. If implementation has not been done, there is non-governance by the central government and the state government. Therefore, you must understand. You must tell the government, responsible government, you are responsible to govern the people of the country. Sovereignty flows from the people of the country to govern the people of this country. If you don't govern, you are not fit to be in the government. Yes, we have advanced. In the education sector, we have advanced. Yes, correct. We have produced a number of engineers, produced scientists, biochemical scientists, doctors, super special doctors, engineers in Arab countries, the doctors in Europe country, in Western countries, but the doctors, after getting education from our country, they are going away to the Eastern countries, Western countries, Europe countries. We don't have the doctors here. Our people, the people who are in the helm of affairs, they go to the Singapore, they go to America for bypass surgery, kidney transplantation. But if affluent people are afford to go at the cost of the public money to Singapore and America, what should happen to a person who is a peasant suffering from the heart disease? A person who is suffering from COVID, he is unable to bear with the expenditure. If he is admitted, he has to sell down lakhs of rupees in the private nursing home. That is the situation. How many cluster of Gram Panchayats you have provided your health? Health is the basic need to the people of the country. Health is the part of Article 21 of the Constitution of India. Healthy life is the judgment of Supreme Court in any number of cases. Right from 1996, Supreme Court has been ruled and held after interpreting Article 21. Healthy life is guaranteed in Article 21 of the Constitution of India. How many people are dying for want of medication? How many pregnants are dying after delivery of the child? How many maternity homes you have provided in rural India? Why you are not provided? Who is responsible for this? Maternity Act, maternity leave is provided. The Maternity Act is provided after delivery of a child, both the mother and the husband. I am a party to the judgment 2013, along with Justice Mukhopadhyay, we have rendered the judgment that 3 months or 6 months leave must be provided compulsorily to the mother and the father to take care of the child. This is what is the job of the judiciary. If the executive fails, if the political executive fails to implement the constitutional, the aspirations, ideals, judiciary must step in. There's nothing wrong. We are not assuming, the judiciary is not assuming extraordinary power under the constitution. If the executive fails, people come to the court, knock the doors of the judiciary. It is the duty, constitutional duty of a constitutional court to interfere and grant the relief to the people of this country. That is the constitutional mechanism and the constitutional democracy. You must understand it before you speak anything. We are not interfering with either the legislature. We are not supposed to enact a law while interpreting. Yes, definitely we agree with that. We have laid down the law. So the Supreme Court has laid down the law in a number of cases that judges are not supposed to enact the law while interpreting the statutory provision of the constitutional provision. That is extra constitutional power. We have held. We are aware of our job. Don't tell us when we exercise, when the executive fails in a public interest litigation, road is not laid down, water is not provided, houses are not provided. If we tell them, issue a mandamus, do it, it is your duty. You are not complied with the part 10 and part 9 and 10A of the Constitution of India and Schedule 10 and 11 of the Constitution of India. If we don't provide education, we will say, we construct the school there. All primary government schools are being completely wound up now because the policies of the government, successive governments, the state governments, they have allowed the private corporate education institutions belonging to the corporate heads in collaboration with the legislature and the bureaucrats today in this country, and completely the government schools have come to stand still. Such state of affair. In the corporate public education institutions, lakhs of rupees donation has to be given. Forget about giving lakhs and crores of rupees donation to the medical colleges, professional education institutions. Today, the primary and the lower LKG and upper KG, you are required to give lakhs of rupees donation. Who will give? Even IAS officer cannot give it if he is honest man. As a judge, I cannot give 1 lakh rupee or 2 lakhs and uniform and lakhs of rupees hostel fee. Who will pay it? Where do you get it? Unless you make illegal gratification, obtain illegal gratification. So today, education policy completely trampled by the private agency in collaboration with the legislators and the bureaucrats. They're wrong, anti-public policy, people's policy. If education is not there, how can you expect people to know Constitution? If merely because you give education of making them as clerks in an education institution or government institution or private institution, that is no education. Education means education to understand nation, education to understand society, education to understand the life. Life includes livelihood, education to understand human values. What is human value? A man who is suffering from starvation, their neighbor must go and give food to him. That is value. If education is not to make illegal money, taking crores of rupees, conducting scams, involving in scams, and diverting the funds of the public money to other agencies to get the money from those contractors, that is not the money. Money, you have to earn, that is money. And we must give opportunity to everybody. Education must be given to everybody. Employment must be given to everybody. Land must be distributed to everybody. That then only you can think of social justice. What is social justice? Social justice to the poor people who are in an affluent position, who owns the car, who owns the bungalow, who wears the dress. That's the social justice. Is scheduled caste man is recognized in the upper caste community people? Is it not the social melody? Can we allow all these things to go on in this country even after 71 years of the written constitution, and the ideals are plenty are there in the preamble and part 3 and part 4 of the Constitution of India. So therefore, my dear friends, justice means social. Social justice must be needed, must be provided. Affirmative action must be taken in framing the policies. In rural India, agriculturists are the backward class people and belong to scheduled caste. Agricultural laborers, the wage must be protected. Minimum wages is not a living wage. That's what Supreme Court in any number of cases we have said. So minimum wage must be fixed. If minimum wage is fixed, these various components must be taken into consideration. If minimum wage is given, it is only for 2 square a meal per day. But to give education to the children, free education must be given, as the Constitution says, up to SSLC. Afterwards, their ambition to become an engineer or a doctor or a scientist or a doctor or a lawyer or a judge you wanted to become, you must encourage him. You must give him, afford him all opportunities to such kind of people to build the country. All sections of the people must be given representation. That is equality. Equality and equal opportunity and equal protection of laws is what is contemplated under Article 14. Article 15, 50% of the population in this country are women. How many seats are you have reserved in parliament? How many seats you have reserved in the state assembly? How many seats are given in the constitutional courts and the district courts in India? Why? How many law graduates are there in your law students are there in your university today? Women, girl students. What is your project? What is your policy? What is your program? These are all the aspects. The Prime Minister, the Cabinet Ministers, the particular education minister, Human Resource Development Minister, Agriculture Minister, Irrigation Minister, Rural Development Minister, every person must evaluate your work, your policies, keeping in view the preamble of the Constitution of India and fundamental rights guaranteed to the citizens of the country. My dear friends, I wanted to tell that equality concept and livelihood. If you say at one breath, all are equal under the Constitution. In reality, all are equal. Can you compare a agricultural laborer or industrial worker and a woman, a homemaker, confined to the respective nature of job? If a peasant, his occupation is only agriculture. Agricultural laborer, he has to do only coolie work in the agricultural field. Industrial worker, he is only a labor. He has to render work for 8 hours or 10 hours today to earn for your livelihood. A woman homemaker, has her only job is to prepare food and to feed the people. Is it the constitution equality concept has not been implemented by letter and spirit with the true spirit and content of the philosophical content, Article 14, keeping in view the justice is the preamble of the Constitution, is the basic structure of the Constitution. Have you not failed in implementing the constitutional philosophy and the constitutional concept? And constitutional democracy is failed. 71 years you have taken is not a short time. That means every limb of the Constitution has failed. The representatives elect adult franchise, People Representative Act 1951, represent the people, go to the parliament and the assembly to enact the law with reference to their sphere of power on the matters which are provided under Part 1, Part 2, Part 3, List 1, List 2, List 3 of 7th Schedule of the Constitution of India. There is no dearth for the laws which are enacted pre-constitutional law, post-constitutional law which are enacted both by the parliament and state legislative assembly. But its implementation is the problem. Why implementation problem? Implementation problem because political executives are not being represented by that section of the society. Farmers' representative is not there. From rural background, MLA or MP get elected. After going to Delhi or their respective capital city of their state, they forget everybody. They forget minor irrigation. They forget about the major irrigation. The Minister in Agriculture Producer Marketing Committee, he forgets the APMC Act to regulate the agriculture produce, horticulture produce, come to the market. Who are the agents who are exploiting the farmers? Your marketing agency. So, failure of implementation of the acts and the constitution to get justice, to get remuneration of the crop which he grows, and market must be, market for the agriculture produce is vagary. The industrial product of toothpaste, industrial product of the cloth, industrial product of the automobile engineer, all fixed rates. It will not vary every day or every week. It varies only in respect of 68% of the population in rural India. Is it equality? Is it arbitrariness? Is it justice? Is it the protection to the people of majority in a democracy? Democracy means what? Majority of the people must be taken care. Majority of the people who elect, they will be elected on representatives of the parliament and the legislative assembly. The concept of majority is only getting elected. Major aspects, my dear students, you please think over, ponder over on these aspects. When you become the lawyer, a corporate lawyer, or a litigation lawyer, or you please come to litigation side. Please come to, if you become a politician, become a legislator, become an IAS officer, IPS officer, a social scientist. Please remember this. This is a country of 135 population. People all must live, share, which is provided under Part 3 and Part 4 and preamble of the Constitution of India. Land belongs to everybody. The river, water flowing belongs to everybody, but it is not reaching everybody. Why? It is a failure on the part of the responsible governments. Therefore, law students, now you have got very good opportunity to embrace every section of society. Please go to the rural India, educate them. Please tell them the constitutional principles. Please conduct the seminars, workshops to educate the people of rural India, educate the people of the lower echelon of the society, so that they can also get justice, what is provided under the constitution. You must remember Pandit Jawaharlal Nehru in the Provisional Parliament, India 1951. He said, is the speech which is recorded in the constitutional judgment by the Supreme Court in Woman Rao versus Union of India, where the constitutional aspects were with reference to the land. That was thought over and pondered over. He said that if I have to implement part 3 and part 4, material resource must belong to the common man. Equality concept should be given under Article 14 and Article 15. Employment must be generated 16. Unless the abolition of landlordism, it is not possible. He said, I don't belong to the landlord class. I am not a tenant. But being the Prime Minister of this country, as long as Article 31 of the Constitution of India and Part 3 of the Constitution of India is there, it is not possible to implement Part 3 and Part 4 of the Constitution of India unless the landlordism is abolished. This is the speech which is extracted in the year 1981 Constitutional Bench in Woman Rao's case. That is why those questions were raised. In Kerala, the first Land Reforms Act was challenged by Keshavananda Bharati, the saint of a religious institution. Supreme Court, at that time, the word socialist was not there. The word, the secularism was also not there. They have interpreted Part 3 and Part 4, keeping in view the entire philosophy and preamble of the Constitution of the human rights of the people of this country, to achieve and to make the country grow, progress and development of a country. It is very much necessary for the Parliament to amend Article 31. Article 31 was amended. 31 was amended. Thereafterwards, the power of the Parliament was examined and examined the tenancy law of Kerala state. They said that 7:6 judges. Power of the Parliament is limited. Power to amend the Constitution is very limited. You shall not amend the basic structure of the Constitution. So Article 31 amendment was held to be valid, and Part 3 and Part 4 held to be valid, and Kerala Land Reforms was held. And in that way, in number of states, land belonged to the landlords were being cultivated by millions of tenants. They became the owners. Their children got education. Their children became doctors. Their children became lawyers. Their children became judges. That's why, to some extent, the justice is given. And they got the social justice and economic justice. That's why country is still progressing. But it has not achieved the optimum level. We have to develop. For that, it is the duty of the central government and the state government to frame pro-people policies, and it should be implemented. In the year 1970, the then Prime Minister has brought the ordinance, 69 ordinance, bank nationalization of 14 banks. 14 banks who are all private banking institutions. Material resource shall not be allowed to, and economic concentration shall not be allowed to be in few individuals. So 14 banks were nationalized. Auto rickshaw people, these small agriculture holding people, the urbanites who are all below the poverty line. The ceiling was there. they were empowered economically, their children got education, bank nationalization to see that economic wealth shall not be concentrated in a few private individual is the basic concept. That's such kind of legislation. The ordinance was struck down in Cooper's case, 11 judges on various counts. Thereafter, Act was enacted by the Parliament in the year 1970. Act was upheld by the Constitution, by the Supreme Court Constitutional Bench. Bank nationalization was upheld by the Supreme Court. So therefore, like this, keeping in view the constitutional philosophy and the concepts which are provided in the preamble, the central government, state government must enact the law. Laws which are already enacted must give an effect to by implementing by the political executives across the country to achieve, to give equality, to give employment. And there must be source of livelihood. This is what Supreme Court in year 1986, Constitutional Bench of the Supreme Court, while examining Bombay Municipal Corporation, slum dwellers, when they were being forcibly evicted from the pavements, public interest litigation by a journalist, the Olga Tellis is a journalist. He went to the Supreme Court, filed 32 petition. Supreme Court has examined part 3 and part 4. What are the rights of the slum dwellers? What are the rights of the pavement dwellers? Supreme Court interpreted Article 14, 19, and 21. While interpreting 21 on the basis of the dissenting judgment of United States of America, but paragraph 32 of the judgment in Olga Tellis, they said that life includes livelihood. Livelihood, there must be, liberty cannot be denuded without providing source of income. Everybody must have source of income. You are answerable. The people who are governing us, either the central government or the state government or local self-government, you have got a duty under the Constitution, constitutional duty to provide source of income to everybody. Nobody is entitled to commit suicide. It is an offense under the Indian Penal Code. If nobody is entitled to commit himself to suicide and die, nobody is allowed to be starved. To provide food is the duty of the government, responsible government, to discharge the constitutional function. Life includes livelihood. Liberty cannot be denuded without providing source of income. Without income, you can't live. So how can you get income? It is the governmental function. So that is the interpretation made by Supreme Court. That is, the law still holds the field. It is the binding precedent, binding on central government, state government, prime minister, chief minister, all the minister, executive, chief secretary, everybody, and including the Supreme Court. Judges must follow this law laid down in the Supreme Court. So these are all various aspects. Now, another important aspect where Jammu Kashmir, Article 370, 5th August, Article 370 itself amended. That is not the scheme of things. What is that? Where was the need to amend Article 370? Again, this question is raised before Supreme Court. Supreme Court is still pending. It's not decided. These are all the issues on the top priority. It should be taken up. The citizenship issue, abolition of Article 370 issue, and the statehood is taken away. Jammu Kashmir state has been taken away and made as territory. These are all the issues which are pending before Supreme Court. These cases you must decide speedily. Not only that, after abolition of the Article 370, 3 chief ministers and the hundreds of people were detained without any reason, and 3 chief ministers were very recently. Their petitions were filed before Supreme Court, habeas corpus petition under Article 32 of the Constitution of India. Those petitions went on adjourning every time. Habeas corpus petitions on the top priority must be heard is the judicial review power, because it is a violation of personal liberty of a person. Those petitions are pending, still pending. And other persons' petitions are still pending, not heard at all. More than 1.5 years is over, 1 year, 4 months. That is not the concept of Article 32 of the Constitution of India. Right from 1967, the then Attorney General, Rende, has said Article 32 itself is a fundamental right. That's what exactly Ambedkar has said. It itself is a fundamental. Fundamental rights are violated. Supreme Court has to interfere and grant the relief. It is the judicial review power. Judicial review power is the basic tenet of the basic structure of the Constitution of India, is what Keshavananda Bharti has said. But Supreme Court is now making observation by the present Chief Justice in Kurappan case, the journalist from Kerala, when he wanted to go and study what is happening in Hathara, the rape case of a scheduled caste lady. And he has been detained, under detention is there. Not only that, not only Kurappan, lakhs of people are languishing in the jail. Those are all people who are not dispensed with the fundamental rights. People who are convictees, people who are in judicial custody are all got the Part 3 and Part 4 rights. Why you are not provided infrastructure to decide the cases of these people? If not deciding these people cases, what will happen? Injustice will happen to them. Justice is not given to them. So these are all the aspects which we are required to remember, particularly law students. Please study in threadbare. Take this, the philosophical concept of constitution to the people of the country. You can be associated with the legal service authority of your state, which is headed by the senior most judge in the High Court of Uttaranchal. You please function. You get the empowerment, economic empowerment, empowerment of women, empowerment of scheduled caste, scheduled tribe, and economically disabled people, so that it will be meaningful effort on your part. Please involve yourself, get justice, what is provided under the Constitution. Thank you very much. There are so many other aspects which I can go on, give lecture for hours together. I think for present today, this much is sufficient. Thank you for thinking of me and inviting me to give special lecture on this celebration of the Constitutional Day. I wish every one of you good luck, all the best for you.
Thank you so much, Lordship. Anushmi ma'am, the mic is over to you for the.
Yes. Thank you so much, Lordship. It was such an insightful session, Lordship. Lordship, we have a question answer session. Can we take up the questions?
Yes, you can take up.
Yes.
Lordship, we'll just take 2 questions for you. Lordship, the first question for the day is, what is the role played by the judicial activism in achieving the ideals of democracy?
That field, the judiciary has not done much, except Kuldeep Nayar's case in Bihar election. It has been held. Democracy conducting elections, either the parliament or legislative assembly elections, must be fair and reasonable. Judicial activism, wherever the fair and proper elections are not held, the constitutional courts, if a citizen goes and approach, the court must intervene and see that fair and proper elections are held. That should be the role of an Indian judiciary. Much progress of judicial activism to achieve democracy, to make the people to participate, at least 90% to exercise their vote. That has not been done. We can't do that. It is for the legislature to enact the law to make exercise your vote must be made as a compulsory.
Indeed, dear Lordship. And in Lordship, the last question for the day to you is, Lordship, the separation of power is neither practicable nor desirable. Your personal comments on that, Lordship.
What? Repeat the question.
Lordship, the separation of power is neither practicable nor desirable. Your comments on that.
No, that's right. the not practicable separation of power is distinct and separate. Article 50 of the Constitution of India. Strictly speaking, when judicial review power required to be exercised, there is no restriction for the judiciary to oversee the functioning of the executive and the legislature. If the law is enacted by parliament or the state legislature, if it is unconstitutional, we can say it is unconstitutional. Your power, exercise of power by the parliament legislature is in consonance with the constitutional principle or not. That can be examined by the judiciary. Third limb of the, there is a separation of power. A judicial review is the entrustment of the power, constitutional power given under the constitution. So to that extent, overseeing the function of the legislature. If the executive law is there, not implemented, if the people come to the court, then we can say, you are not formed the road, you are not provided the health facility, you are not provided the drinking water, you are not provided the shelter to the needy people, which is your job, either the local self-government or village panchayat or the other agency which is required to provide it. Then it cannot be said that judiciary is interfered in the functioning of the executive. If you fail it, or if you don't do it, action or inaction, action is arbitrary, we can interfere. The inaction also we can interfere. That cannot be construed that we have interfered beyond our powers. No, it is practicable. Yes, practicable to the extent enact the law. It is in consonance. If it is not consonance with the constitution, we can interfere. Then it is not impracticable. It is practicable. That means the power we are exercising.
Thank you, Lordship, for answering the questions. Now I would like Anushma ma'am to take over the dais for the vote of thanks. Anushma?
Vishal, thank you.
Yeah. Yes, ma'am. Yes, ma'am.
I take this opportunity to thank Justice V. Gopala Gowda, who has very rightly said what are the objectives of this constitution, our living constitution, the purpose for which was to give justice to the people and how it must be used positively for attaining and implementing social justice. So, sir, your words to the students, I am sure will motivate them in their career whenever they take up issues which face them in their lives, and they will use their empathy, their knowledge, and their understanding of the constitution to see that how effectively they can help in order to empower the weaker section. And it is true that the objective of the constitution was to bind us, to protect us, and not only one or a few of us, but all of us. So, sir, your words have been immensely appreciated, and we are highly thankful to you for taking out your time and giving us such wonderful insights into what are the rights and the duties and how the state must function in order not only to protect as a sovereign state, but responsibility of individuals to have a strong and sovereign state. So if we want a true democracy, we also must fulfill our duty. And we will promise to work with the Legal Services Authority, which we do by holding camps and other acts. And I'm sure that the students will take light of whatever you have said and work effectively in these areas. Thank you once again, sir, on behalf of ICFAI University, Dehradun, for being with us and talking to us. Thank you, sir.
Thank you so much, Lordship. Thank you so much.
Thank you very much.
Thank you, Lordship. Thank you very much for your kind words and which has motivated and inspired my students. And in future, they will do accordingly. So your advices will be taken care of. Namaskar. Namaskar.